respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated, thank you.
I instruction to proceed with an application for leave to appeal in terms of section 391 and 309B.
May we, Advocate, sorry, John, not to interrupt you, may we just deal with the section 103 inquiry and then we can proceed to that part. I assume you are ready for that part as soon as we've dealt with the 103 inquiry.
Yes, Your Worship, and full bail pending the outcome of the appeal.
Certainly. Okay. Let me just find my notes. Just as a brief explanation to unless it's not clear, the next step after sentence is that the court is obliged to deal with the provisions of section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances. And the inquiry in terms of section 103.1 Act 60 of 2000, since in terms of section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in section 103 subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Odious? No submissions.
The accused does have a firearm license. It's been recorded previously.
Thank you. Advocate Caesar, on behalf of the state?
The accused should be declared unfit to possess a firearm.
Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit, and it is followed by the following further order by court. That what section 103 subsection 1 read with the provisions of section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization and permit issued in terms of this act to any person who becomes or is declared unfit to possess a firearm in terms of section 102 and 103 cease to be valid from the date of the conviction or the declaration as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of section 102 or 103 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations and permits issued to him or her in terms of this act, all firearms in his or her possession and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act. So what we are left with is the application. Are you ready to proceed now? We'll just get that part of it ready.
So what we left with is an application for leave to appeal against conviction and sentence, and an application for bail pending the outcome of the proposed appeal. If the leave is not granted, then it will be bail pending the outcome of the petition.
Just a minute, Advocate. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully. Just a minute. Thank you. I'm ready.
Thank you. So this application for leave to appeal in terms of the provisions of section 309(1) and 309 capital B of the Criminal Procedure Act 51 of 1977, which provides that we can commence immediately by oral address, provided we list all the grounds. So it's an application for leave to appeal to the High Court of South Africa.